Well, good afternoon, everybody. This is Michael Johnson, the CEO of FCS Community Management. We're grateful to have you with us today for our first virtual board lunch and learn. You bring the lunch and we bring the learning, and we're excited to continue with our programs. We skipped last month's program because it was at the beginning of the coronavirus, and now that we're in the swing of things, it's time to continue with our board education series. Today, I'm coming to you from our Draper office, where I'm coming in only on Tuesdays of each week, and just happens to be the day that I'm here. But we've been broadcasting each week our webcast, Monday Night Michael, and those have been very successful on Monday nights. We just had our fourth one last night. And you can go to our website, and I'll pull over and we'll see if this works. Hopefully you can see the website now. But you can go up, and we have a couple of things to look at here, but you can go down to the board training, and you can go to Lunch and Learn for these programs. But if you go into the Monday Night Mike, we have loaded up the programs, and so if you go to this webcast library link right here at the top of the page, all of the webcasts from the Monday night programs where we've spoken exclusively about dealing with the management of our associations during this coronavirus time period. And so last night's will be posted later this afternoon as soon as it's converted. Also, the slides from each of the webcasts are there as well to assist you. You can also go to the COVID-19 information link, and this is where we are starting to build the resources as we introduced last night in our webcast. But here you can find a link to the Utah Leads Together, Governor Herbert's directive for Utah on the phased reopening of society. You can see the phased guidelines for public and businesses. So this is where you see the governors and the state's recommendation for reopening playgrounds and parks and gyms and clubhouses and your hair salon and all the different restaurants. All those different things are all contained in there. And then we will finalize and get posted today what we presented last night, the FCS Leads Together, which are our recommendations to limit liability for associations as you reopen your common amenities. And so that information will be posted later today, and you can watch the webcast from last night to kind of see the general overview that we presented at that time. Running through the slides since I just cheated. Well, there we go. Here's us today. So we talked about in the FCS Leads Together, our goal is to reduce liabilities for you and your associations. And we have a program today to talk about liabilities that each of us as association board members have exposure to. And I'm pleased today to share this webcast with three others from the insurance industry. Lamond Woods, which many of you in Utah already know. Lamond has served 25 years as an insurance provider and risk transfer specialist. He's a senior partner at Century West Insurance Services, obviously specializing in risk management for community associations. Lamond has received the designation of Community Insurance and Risk Management Specialist, otherwise known as CIRMS, from the Community Association Institute. He's a past board member of the Utah chapter of CAI and has served as chairperson of the Legislative Action Committee for Utah. As a member of the committee, Lamond worked directly with the drafters and legislators on the language for SB 167, which is about 9 years old now. It became law in 2011 and dramatically improved the insurance scheme for community associations in Utah. Lamond always seeks out and implements innovative ideas to more efficiently and economically provide insurance for associations. He's a board member for a resort condominium up in Park City. Susan Merisko is the Regional Sales Executive for the Mountain Region for Distinguished Programs and is responsible for strategic growth and broker development. Susan has dedicated 30 years to the insurance industry, holding key leadership positions as Regional Business Manager, Regional Underwriting Manager, Regional Sales and Marketing Manager, and Assistant Vice President, Business Development Manager, Western Regional Leader for Fortune 500 insurance carriers and within the independent agency distribution channel. In addition, she has been called upon for industry expertise and to serve on regulatory subcommittees with the Department of Insurance and the U.S. Department of Housing and Urban Development concerning insurance-related topics. Our final presenter this afternoon is Margaret M Mcburney. She's the Vice President and Program Manager for Community Associations at Distinguished Programs. In this role, she leads strategic growth initiatives for all community association-related lines of business. She joined Distinguished Programs in 2014 as the Vice President of Claims to serve as the company's claims liaison, with a focus on providing claim expertise to the company and its insurance partners. She obtained her law degree from Seton Hall University, the School of Law, and is licensed to practice in New York and New Jersey. She began her career as an insurance defense attorney and has firsthand experience defending, evaluating, valuing, and settling claims throughout the United States. So I think you can see we have a great panel today, and I'm pleased to have them on the program with me because then it makes me look better. So I just wanted to quickly talk about risk management and insurance. This is, when I go out and have taught all over the world to community managers in our field, we spend half a day on risk management and insurance in our 2.5-day class. Then there is a 2-day class by itself just about risk management and insurance. And I'm not going to lie. For me, it is really the most complicated topic that we as practitioners in the field need to understand. This is, we say all the time, community management is not rocket science. But this risk management and insurance, just because of the pure amount of details in the policies can be immense in the things that you need to know. And I highly recommend we as community managers here at FCS don't try to overstep or take the place of our insurance agents and brokers. It's just there's no point to that. We go to the people who have the expertise. But remember, insurance and insurance policies are simply a form of risk management. And what are we looking at? Now, here's some of the things. These are the terms that we try to get everyone to understand in just about a couple hours in our base community management course that we teach to people around the world through the Community Association Institute. Lots and lots of things to understand. So remember, what are the exposures that we have in our community association? There's basically 4 types of exposures that we are at risk. Our property exposures for both tangible or intangible properties. Our real property, that's our buildings, our land, our information, and our personal property, our inventory, our furniture, our supplies. We also have liability exposures. These are third-party claims of personal or property damage because of actions or inactions on our parts. Income exposures. Have we experienced a net loss, a reduction in income, or an increase in operating expenses because of an event? We're hearing a lot of information right now about income exposure related to the coronavirus. And I think the insurance companies are coming down that it's an act of God, and so it might not be covered. A decrease in assessments generally is not covered as an income exposure. The income exposure is more like, say, you have a large clubhouse and you rent it, and you have the ability to rent it out for weddings for $1,000 a night. And now, because of coronavirus, you've had to cancel 30 of those. Now you have less income. Or say, heaven forbid, there's a fire and your offices for your on-site staff are in that building and they no longer can be in there in the office while it's being rebuilt. We have to bring in a temporary trailer. It's in the parking lot. Therefore, your operating expenses may have increased. And I'm sure I've butchered that, and all the insurance experts will tell me that in a minute. And then personnel exposures. These are claims from employees. So these are our exposures to loss in the insurance world, in the risk management world, that each of us probably in our associations have each of these risks to some point or another. Now, we have a lot of associations that have no property exposures. Any property they own might be a little bit of a storm retention area, so there's not a lot of personal property there, but there are liabilities. And so we need to understand. So today we are talking about liability exposure specifically. So what are the things that we do for risk control in our associations? One's exposure avoidance, right? So we are going to store the pool chlorine and acid in a secure environment away from the public. Loss prevention and reduction. If we have valuable things, we're going to lock it up so it can't walk away. We're going to secure our information that's on our computers. Segregation of exposure, right? We're going to split it amongst others. And then contractual transfer. Contractual transfer is when we contract with your landscaper, we're requiring the landscaper to carry the insurance for them being in your community. Where do we find our insurance requirements? They come in these areas. One, our state statutes and regulations. There are requirements for certain insurances that you have to have. If you have workers, you have to have workers' compensation insurance. It's not optional. Our association governing documents. Every month we talk about this. The governing documents are the source, and it will often list in community association documents the type of insurances, the minimum coverages you need to have for your association. Local and federal laws, the secondary mortgage market, agency and lender requirements. So our friends at Fannie Mae, Freddie Mac, FHMA, all those guys have lender requirements. If they're going to insure mortgages, they're going to make sure that there are certain protections in place. Contractual obligations, like we talked about, you might have an agreement that requires you to have the insurance. You might have a community event at a public park and the city requires you to buy a little insurance event package for that. And then just the good business judgment rule, what any reasonable person would do to protect people. You don't have to be experts in these things. You just have to have enough knowledge to know that we need to go to Lamond and the insurance specialist to help us make sure that we're meeting our obligations and covering our risk. So property coverage, just really quick, once again, that's our commercial package policy, mechanical and equipment breakdown, ordinance law insurance, flood insurance, and our electronic data. Income coverage is Fidelity coverage, so the Fidelity coverage that you have to prevent theft of your funds, that we also cover our own policy as a company so that our employees don't mishandle funds. Business income insurance, assessment fees, receivable insurance, There is some policies like this. Not too many folks in Utah have this rider, but it is available, and extra expense insurances. And then the personnel coverages we talked about are workers' compensation, employer's liability, those kind. And then the liability coverages is what we're focused on today, which is our CGL, our Commercial General Liability Policy for your association. Hired and non-owned automobile liability. This covers you as a board member. If you are traveling in your personal vehicle doing association business and were to get into an accident, and the person that you're in the accident with finds out that you were on association-related business, you could have a liability exposure to the association. Therefore, there is a hired and non-owned automobile liability policies. The commercial umbrella policies, which extend the limits on all the other policies. And then finally, our directors and officers liability. We'll be talking next month about, I believe it's the commercial general liability policy, but this month it's directors and officers liability. And everyone thinks, I think, that there's just a general, this is what it is. But there are a couple very different and unique types of products with very different coverages, and it's important that we understand those today. Now, the last point I'd like to get before Lamond talks about those different kinds of D&Os is when evaluating insurance agents and brokers, make sure that it's just like we tell you for attorneys, for your associations. There's a lot of general real estate attorneys out there. There's a lot smaller number that focus on community associations. Those are the ones who should be doing your legal work for your communities. Insurance is the same. There are lots and lots of brokers for insurance. They are not necessarily skilled in the community association realm. Very small number here in Utah who have the expertise to take care of your association. So look at experience, their specialty in this specific field, their knowledge of associations, claims processing history, participation in professional and trade organizations, like we talked about Lamond being involved with the Utah chapter of CAI and also with the Legislative Action Committee and actually helping write and draft laws that are in place today, their professional standing, their licenses, and their bonding, and then that the CIRMS, Certified, it says Community Insurance Risk Management Specialist, I think is what that is, and actually I had pulled up a website, but I took it down. But if you go to caionline.org, you can learn more about the CIRMS designation. It's the top designation for insurance folks in our industry. All right, I'm going to unmute our friend Lamond here. Lamond, can you, are you hearing us good, Lamond?
Yes, I can hear you.
Welcome to the program today, and I'll just turn it over to you.
Fantastic. Thank you for the introduction and explanation on insurance. As Michael said, we're going to cover in detail directors and officers insurance. And the one thing I want to leave with you or make sure that we hit on heavily is that with directors and officers insurance, not all policies are created equal. Michael alluded to the CGL policy that refers to the Commercial General Liability Policy. That is, in a lot of cases, they're standardized forms used with many insurance companies. So what a policy that you purchase from company X may have the same forms as a policy purchased from company Y. That is not the case really in any measure with directors and officers insurance. So again, we're going to talk about those. Michael, take me to my next slide. The easiest thing in determining if you have a robust directors and officers policy is pretty simple. And I made a note, make it simple. So the easiest way to tell if you have a robust policy is first to check this. do you have a separate standalone policy that's not associated with any of your other insurance? If it is, you'll pay a separate insurance premium for that. You'll have a separate policy, obviously. The opposite of that is what is referred to as an embedded policy. An embedded policy is going to be an endorsement to an existing policy. So we've talked about property insurance, liability insurance. There could be some fidelity or crime coverage, also known as employee dishonesty. But then you would also have this endorsement thrown in there called, well, an embedded directors and officers insurance. The things showing on the screen there in red are all items that I took out of a policy that I was reviewing recently that is an embedded policy. We have some wonderful folks that I'm excited to hear from Distinguished Programs. They are the program manager for Great American Insurance. Each one of these things that we're going to cover as exclusions in an embedded policy are all covered, and Meg and Susan will talk more about those. But here's a list. Failure to maintain insurance. That's excluded under the vast majority of embedded policies. Failure to maintain insurance. Might you be sued for not having earthquake insurance? Well, sure, you could be sued for a lot of things. Is there inadequate fidelity coverage? You want the defense coverage that comes along with a good, robust policy. Insured versus insured. This would be one board member suing another. Breach of contract. We had this happen where an association canceled their contract for their cable company. It could happen with any contractor, a landscaper as well. But in this case, the company canceled the contract with the cable carrier. The cable carrier sued for breach of contract, and in that case, the D&O policy paid for the defense. Now, there's a term called final adjudication. Insurance will not pay if you're found in breach of contract, but they're going to pay the defense to get to that point. This next one, what a claim means, is absolutely the most important. In fact, I wrote a note, it's going to be in one of our later slides, where the second most common claim for a community association is a non-monetary claim. Now, you may think all claims are about money, but that's not the case. And again, I'll leave that for Meg and Susan to talk more about. In this definition, a claim means a written demand for monetary damages. So in this policy, the only way you're going to get coverage is if someone is suing you for X amount of money. And again, we'll have examples that those claims are not the most common. Yes, they are common, but maybe less than half of the claims. And then the last item I listed there, just the definition of a suit, means a civil proceeding in which damages because of a wrongful act is alleged. So the key there is a civil proceeding. Again, a lot of these claims don't get to an attorney or to a court. They are someone wanting to have multiple pets, someone wanting variance with architecture. And another thing I didn't put in highlight, that most of those embedded policies do not include coverage for the manager. And why is that important? Well, in virtually all management agreements, you have a responsibility to indemnify and hold harmless the manager if they're acting in good faith and taking care of the association. And if they get named in a lawsuit, you'll want coverage for that, because if you don't, you'll have to be paying for that out of pocket. Let me see. I mentioned just again about Great American and Distinguished Programs. There are only maybe a half a dozen really strong, and probably less than that, really strong D&O products that were built specifically to cover the needs of a community association. And again, I'm grateful that Meg and Susan made themselves available to join us today. and I'll turn the time over to you guys.
Okay. All right. Thank you, Lamond, for that information. I'm going to go ahead and, Susan, make you the presenter. Just a moment. And I'm going to unmute you, Susan, so we looks like you are ready to go.
Perfect. Thank you so much. Meg and I just truly appreciate the opportunity to join you all today in this very non-normal time. Thank you to you, Michael, and certainly to you, Lamond, as well. We appreciate really the opportunity to talk about and just to provide you an overview of the Directors and Officers Insurance. I think what's important is with any insurance, it's understanding the value but also the purpose of the coverage. Unfortunately, too many times when it comes to insurance, decisions are made on affordability, and so hopefully we can provide you with some oversight as far as the value of what this coverage really is. So we'll start with really why is this so important today? As you all know, as community members, we're personally invested in the good and the betterment of our neighborhoods that we live in. In fact, we're willing to devote our personal time to this. And because of this, most board members are actually generally volunteers and have all good intentions. So who would sue me for volunteering on a board? That just seems like, why would you do that? Well, this is where the informality ends. Community associations are actually legal entities that are governed by laws and conditions and rules and bylaws with the directors and officers at the core. And it's the directors and officers that ensure the association follows their rules. But it's unintentions that may predicate future claims. Boards, as I mentioned, are primarily comprised of volunteers, but they may lack experience or training. What does this mean from a coverage standpoint? Well, the potential claim is there may be failure to follow or know what the bylaws are. It's interesting in that many boards have a legacy of board members that year after year after year volunteer. It's generally when a new board member joins that maybe something might be brought to their attention because they're looking at it from a new set of eyes. Maybe it falls into handling things informally. Again, it's a very casual environment a lot of times. And because of that, there's failure to actually document or memorialize any of the updated governing documents. Or, quite honestly, it's just not knowing. And again, I mentioned that this may be unintentional, but if it's just ignoring the government or governing documents, this too can result in a failure to enforce or provide consistency, which quite frankly may result in discrimination. And emotional. These are our neighborhoods. These are our homes. These are what we're about. Too many times we become emotional as humans, and community associations are not exempt from this. What can this result in? Potential slander, libel, or even defamation of a board member. So what we're talking about is really lawsuits that are filed against association volunteers. We're seeing that this is on the rise on a national level. Most of these, as Lamond has mentioned, are not monetary, but instead arise from a decision made from a board that is a decision that is challenged. It can be as simple as an architectural design or not enforcing a rule consistency. Today, people don't have qualms about suing their neighbors or their community association. So as we go forward then, as we look at this, why do you need insurance? In a simple sense, think of your directors and officers policy as a defense policy. Claims against the associations are generally comprised of defense fees, expenses associated with claims and litigation costs, and it's not uncommon. But a lot of times in talking about insurance, what is it not intended to do? A director's and officer's policy is not intended to cover wrongdoings. In fact, what would that mean? Well, again, in a simple term, that would mean that we're condoning immoral behavior. So a D&O policy is not intended to cover criminal or intentional or malicious acts that are committed deliberately. And deliberately is a key word. It's also not intended to cover bodily injury or personal injury of a person or physical damage to a third person's personal property. What this means is this is where your general liability policy can provide coverage for your bodily or personal injury of a person. Most general liability policies will also cover physical damage. This is also why it's recommended that a board has both their general liability and also their directors and officers policy. Again, this is where talking with an educated and knowledgeable agent who understands community associations can really help you understand what you need as a board. But by far the most common cause of problems is not following the governing documents. It's very simple. Many decisions are done informally, as I mentioned before, and are done the same way year after year. So what does this mean as far as considering a policy?
Susan, I'm just going to jump in real quick.
Sure.
It looks like I'm getting a chat that we're seeing the lecture part of your screen, and so the slides are a little small.
Oh, okay.
We're seeing the next slide, and so it's a little small. So I don't know if you have the ability to blow that up.
Let's see if we can do that for you. Hold on one second. I apologize. Let's see if I can make this. Oops.
We can see it.
You can make it full screen, Susan.
Yeah.
Like make your slideshow full screen.
Let's see.
Screen.
Did that work?
No.
Now we're seeing you.
Oh, no.
And that's okay.
Oh.
You want me to,
Yeah,
send it back to you?
that would be great.
All right.
Thank you.
Thanks everyone for your patience. Let me just grab this real quick, and I'll send it back to Susan in just a moment, so you guys can see that a little better. Now we will take these slides, and we will have them printed and available on our website, including Susan and Meg's slides. So you will be able to see them. There we go. Now, I saw it for just a second. So let me try again. All right. Did it ask you if you wanted? I see. There we go. Now we're seeing. So if you make that, play that, then you will have the full screen.
Perfect. So you should be seeing a screen that says you get what you pay for?
No, we see the first slide.
Oh. Not sure if I can.
Well, if you use your down arrow, it'll probably switch to the slide that you were on, and this is a little bigger than it was, so I think we would be...
Yeah, it's not showing on mine. I'm so sorry. It's not showing now on mine.
Here's what we'll do. I'll go ahead and put it up on my screen, and then if I don't instinctively figure out when to change it, then you tell me to change it.
Absolutely.
All right, let me get there. You get what you pay for, and all right, do you see it up on the screen now?
I absolutely do. Thank you.
All right.
I think that, so what an apropos thought to be. It's quite frankly, is you get what you pay for. And to Lamond's earlier point is that insurance is different, and it's knowing what those differences are. But community associations are budget driven, and it's an important role of the board actually to ensure that they purchase and maintain proper insurance. So what kind of policy do you need, and how much coverage is enough? Again, to restate the obvious, not all policies are created equal. Typically, the broader the coverage, the better protection the policy will afford the association's directors and officers. So things to consider. What is the definition of an insured? That may seem very obvious, but it's very important to actually look and read the policy to know, does it include coverage beyond the directors and officers? Does it include a property manager? Does it include a developer who might also be appointed as a board member? How about past, present, and future board members? Again, these are all important individuals to consider, but also spouses of directors and officers. And that one always makes people stop for a moment and say, really? But they may not be part of the associations. But again, what you're talking about, though, is anyone that is participating as a board member may have their personal assets at risk if not properly covered. So this may bring into spouses. And also, unless prohibited by the bylaws, sometimes in some situations, you can have both spouses participating on the board. Can they both be sued? Yes. Can anyone on the board be sued? Yes. Generally, this may be by a disgruntled homeowner. But again, these are generally not successful, but it may be happening as a tactic to put pressure on the board. Generally, board members are only personally responsible if they breach a fiduciary duty of the association. So what else, if we move forward, what else does the policy provide for? The most important thing is consider the potential defense cost and then consider if a policy reimburses the board for incurred expenses. What does that mean? Well, are the claims, if they incurred, are they out of pocket for the board and then reimbursed, or are they paid on behalf of? Very important, because from a budgetary standpoint, you may not know or expect to know what type of claims you, as a board, you may be incurring. Non-monetary claims, we'll talk about those specifically as far as what those may mean. While they may not derive any kind of financial situation, they are certainly, from a legal perspective, required a defense. Does the policy provide for wrongful termination, illegal forms of discrimination? Can it defend against claims or lawsuits for failure to maintain or obtain insurance? Does the policy provide coverage for decisions directors and officers make in accepting and rejecting contracts? If you're answering yes to these are the type of coverages that you need to look for with regards to the insurance policy. Any person who serves on a board where they do not have coverage that will defend them against a claim or a lawsuit, quite frankly, has inadequate coverage. Most claims do not involve indemnity payments, but instead, again, and it's redundant, but it's important to hear, is that it's the attorney fees and the costs that make up the majority of the payments. So in the end, the best coverage is really the one that provides the best coverage for your own board. And that's an individual decision. But the cost is really associated with what is the exposure or that you're leaving the board exposed to. If we move forward, we talked about non-monetary claims. These are the second most common lawsuit behind discrimination claims. And what this boils down to is consistency and fairly applying the rules to everyone. Most of the time, claims brought against the board are going to be non-monetary. And in this case, they're not seeking money, but instead they're asking the court for a declaration that the director or officer has acted wrongly. I've listed some examples. We've talked about a failure to adhere to the bylaws, perhaps challenging assessments, simply as not properly providing notice of elections, properly counting votes, someone complaining about the color of a neighbor's home. Again, you think about this and the consistency. One neighbor has a fence, another one can't. One member has pets, another one can't. You can see it's an unfair accusation is probably the best way to say that. So why is it important to also have your property manager on your policy? The choice belongs to the association to self-govern or hire a professional. But if you elect to hire a professional, it's important that they are incorporated into the governing documents. Property managers are professionals who know what the board and the association need to do, and they can help facilitate board functions and carry out board directives. Because of that, they can be sued for their own conduct or the conduct of the association. For any association that has an indemnity obligation, it's in the property management contract as well. It can be a major expense for the association to provide a defense to the property manager, especially when the association would be out of pocket for these expenses. So again, this is a financial investment as well, but in the end, it may help mitigate many problems that can turn into a claim. In conclusion, it's really important to read the policies carefully, know what the coverages are, but also be familiar with the exclusions before there is a claim. So I think you got a sneak preview. What kind of claims are there? And I'm going to turn it over to Meg, because Meg, being an attorney by trade, will provide you with some of the situations that we've actually had some experiences with that you might appreciate understanding and seeing from a claims perspective.
All right. Thank you, Susan, and thank you, Michael and Lamond and everyone else for having Susan and I today. I'm going to go through a few claim examples that I think will illustrate some of the points that everyone here has made on the call so far. And this slide is just a funny, look, Bob, I've painted my fence, but it does illustrate sometimes the personal nature of these claims when they occur, because it's between neighbors, really. And sometimes that leads to heated or elevated emotion and feeling and can increase the cost of a claim. And I have one example of that sort of at the end of the presentation. But before I get into the claim examples, I wanted to make one note about carrier-appointed counsel. Now, I did an audit of carriers' D&O files recently, and a lot of policies, especially these standalone policies, will allow you to choose your own counsel. And I would just put a word of caution in about choice of counsel. The carrier or the counsel that the carrier is appointing, they have experience and expertise in this very specific type of litigation with associations. And their goal is always going to be to represent the best interests of the association, but to also try and resolve the claim while balancing the cost and the time and the energy and the effort to do so. Sometimes when boards select their corporate counsel to represent them, what I've seen, and this was true in the audit that I did of the files, and I understand why a board would want to choose their corporate counsel. There's already a relationship there and a level of trust. But sometimes those individuals or attorneys were the ones who were involved in the decision-making that could have led to the litigation in the first place. So that's certainly a risk. And also there tends to be an increase in cost, expense, and the time the litigation lasts, as opposed to the carrier's assigned counsel. So, if you ever have any hesitancy, I would just advocate for allowing the carrier to appoint counsel. I've seen very, very good results across the board in the files that I've looked at. All right, so the first claim I'm going to cover is a fight over a 4x4-foot closet. And now this involved the failure to document decision-making and to also maintain records. So the facts. The insured was sued by one of its long-term residents. This gentleman moved into the association in the 1970s. And at the time, he was told by the property manager that the closet that was in the hallway outside of his unit belonged to his apartment or to his unit. And he proceeded to use it for the next 25 years without incident or issue. In 1995, a new property manager came along and told the claimant that all of his property would need to be removed from the closet because it was the property of the association. The claimant refused to remove any of his belongings. So the association began to charge him closet rent. The claimant refused to pay his closet rent. Finally, in March of 2018, this issue finally came to a head, and the claimant sued the association. And he was arguing that he had the exclusive right to the closet space either through the governing documents of the association or, he had taken possession of it for so many years that, it was now his. So what resulted was 1 year of very costly litigation. There were a lot of extensive settlement negotiations between the parties, and they finally agreed to settle the lawsuit, and these were the terms. The claimant would be allowed to use the closet. He would own the rights to it, but he would have to pay the association all of the past due closet rent charges. And then as part of this settlement, the carrier had to agree to pay the claimant's attorney's fees, which were $23,000, as well as their own defense fees, which were $60,000. So at the end of the day, this claim cost the association's carrier $83,500, and it was all over a 4-by-4 foot closet. Now, claim number 2, this is something that we see quite often in, I would say the West Coast, the mountain areas, and it involves landscaping. There's often these disputes that arise out of landscaping issues, whether it's a retaining wall or tree roots. And again, this one arises out of failing to know what's in the governing documents of the association, and then a failure to follow those governing documents. Now, in this particular case, the facts were the association had a small contingent of homeowners, about 18 homeowners. These 18 homeowners had extra, special, unique, fancy landscaping, and the association paid for the upkeep of that landscaping at its own expense for about 20 years. Now, there was a homeowner who was not part of this special group of 18 who was not having her landscaping paid for by the association. She was doing it at her own cost, so she sought reimbursement from the HOA. The board then went back, they reviewed their governing documents, they realized actually they shouldn't be upkeeping the landscaping of these 18 homeowners. The bylaws dictated that they should be doing it at their own expense. So the association notified these 18 homeowners, hey, we're not going to be able to pay for your landscaping anymore. Well, the 18 homeowners then refused to keep it up themselves. And now there's this dispute between people who are having it paid for, who are no longer having it paid for, and the properties fall into disrepair because they're not going to keep it up themselves. Now the city gets involved. They're filing a complaint against the association, stating that they're going to be fining the association for every day that the association doesn't clean up this property because there's a city ordinance preventing it from falling into disrepair. And so then the, the 18 homeowners also file suit because they want to force the association to continue to pay for their special landscaping. However, if the association agrees to pay for that special landscaping, all of the homeowners over here who are not having their landscaping paid for are going to also sue the association. So the association is stuck in a hard place with the, no matter what decisions they make, they're getting sued and involved in litigation. And this is going to be quite a costly suit for the association to defend. Now, the carrier is treating all three of these matters as separate claims, and each one has a $25,000 retention or deductible. So it could, if it's not resolved quickly, ultimately cost the association $75,000 in defense costs out of its own pocket before insurance will fully kick in. This lawsuit is still open. It's still being litigated, and one of the retentions has already been exhausted. So you can see how quickly the legal fees add up in one of these cases. Now, this is another claim, number 3, the window dispute. Now, this one happened in Washington, D.C., but really it could happen anywhere, because what this really is, this case is a perfect example of the failure to put emotion aside, to let ego get in the way, and to really just get involved in a knockdown, drag out, battle to the end. So in this particular case, the residents of the association were, federal judges, there were foreign dignitaries, there was at least one former spy, and a second in command of a large federal agency. Now, 3 of the board members were sued by 2 of the homeowners. These 2 homeowners were a married couple, a physics professor and his wife. She was the proprietor of an African safari travel service. They were suing the 3 board members because they were not allowed to put in, or the HOA refused to allow them to put in the windows of their choosing. They had a certain type of window that they wanted installed in their property. 2 of the board members out of the 3 demanded that they have separate counsel. They claimed that there was a conflict. Their choice of counsel turned out to also be an owner in the association, which was not disclosed to the carrier at the time that they requested consent to use their own counsel. And it turned out, of course, that this other association owner who was an attorney who was going to represent them had his own personal grudge and dislike for the claimants. So what resulted was 2.5 years of litigation, and it cost over $250,000 in defense fees for the association, and in the end the claimants did not get the windows that they wanted. This is a really good example, too, of one of those non-monetary claims that ends up being very, very costly for an association if you don't have the right insurance. Here, they're just fighting over the right to install the window that they want, and $250,000 in defense fees later. That's the result. And then another example, and I don't have a slide for this one because I didn't really know how to put up a slide for a contract, but this is an example of tortious interference with a contract. And in this one, we had a Colorado homeowners association who was sued by the homeowner who was attempting to sell her house. Now, she alleged that the HOA was the reason that the buyer terminated her agreement of sale. She said that they told the potential buyer that he was going to be required to pay significant amounts of money to remediate soil contamination on the seller's property. Defense counsel was assigned, and very quickly this story unraveled, and it was found that that wasn't actually the case. The buyer learned of the contamination on their own. It was their choice to pull out of the contract. The HOA had nothing to do with it. And still, to settle the case and not spend an exorbitant amount in defense costs, the carrier paid $5,000 towards settlement, and it also cost $21,000 in legal fees to settle. So it's another example of, even when there's really no liability on behalf of the board, just to bring a case to a rapid conclusion, sometimes the carrier will have to do an assessment of, okay, if we drag this out, or if we choose to fight this, how many years will it take? Could this turn into one of those 2.5 and $250,000 cases, or can we wrap it up quickly, which is really in the best interest of the association and the board members, because litigation is always a time, energy. It's very emotional, especially when, like I said, it's your neighbors. It's a drain on everyone, and so it's always in the best interest of the association to move on from litigation as quickly as you can. And I know we only have a couple minutes left. Those were all the specific examples I had. But I did want to talk a little bit about some of the trending claims if I had more time. One of them is discrimination claims, which Susan touched on a little bit. And these are becoming more and more common for community associations where, again, this is a non-monetary claim, but associations are being threatened or having discrimination charges filed against them for things like, you know, I want a fence, he has a fence, I can't have a fence, his fence is too high, you're not letting me do what I want, my house is the wrong color, and often what can happen is a prior board says some act or behavior is okay, that is not documented, and then a new board takes over and says it's not okay, or it's not okay for someone else to do. And that's when you get the discrimination claim. And again, there's a lot of costly legal fees that can result from this. So it's essential to keep good documents, especially at the point of turnover from one board to the next. And when you are on the board, maintain those good documents of all your decision making. And when you make exceptions to your governing documents, always keep a record of that as well.
Meg, are we starting to see I know HUD has said that associations are now liable if two private parties are discriminating against each other. So a homeowner is walking down a hallway and throws out some sort of discriminatory language towards another homeowner. And HUD has ruled, we don't like the ruling, but they've said it can be the association's responsibility to get involved in that private action. Are we seeing any lawsuits on that kind of bizarre ruling from HUD on that's a discrimination case?
In certain very specific examples, you know, you will see lawsuits arising out of fact patterns like that. It's very difficult for the, you know, complainant, I would say, to prove that case. But like I said at the beginning, it's really not about proving the case. Often these don't go to trial, and so they end in settlement. And so to get to the point of settlement, you know, now that there's that extra hook that people have been given, you know, yeah, there'll usually be some sort of settlement agreement and fees associated with it. Go ahead. No, you go.
We are about out of time. I want to turn on the Q&A really quick to see if any of our board members have a question they'd like to ask anyone on the panel. So let me turn that on really quickly here. Just click the Q&A button on your screen if you have a question you would like to ask to Lamond or Susan or Meg. They did such a fantastic job. There probably are no questions. I feel like I could go and be an insurance professional now. Okay, I don't feel that. I don't feel that way at all, and I never want to do what you guys do. All right, looks like we have a question from Scott. Scott, let me get to you just a moment.
Hi, Michael. Thank you. I appreciate the opportunity to ask a question. Great presentation. His question's for Megan. I was wondering if she happens to have notes for the cases and the examples that she cited. I would like to be able to provide those, if they're available, to the other board members who weren't able to be here today and who won't be able to access the slides on the FCS website.
Yeah, I can provide those to Michael at the end of the presentation to distribute to anybody who attended.
Thank you very much.
Thank you, Meg. Thank you, Scott, for your question. I don't see any other questions, and so I am just going to say thank you very much once again, and to Susan and to Meg about our presentation today and taking time out from their schedules. As you can see, it's still a different time. We're working from homes. We're working on skeleton staffs, and we appreciate all that each of you board members do in serving your associations and spending a little bit of time today to better that service. These are the kind of the things the insurance counsels have told me before, that when a board can prove that they're trying to better themselves and learn the best they can do without having to be an insurance expert, it provides a good defense for their community that they're doing the best that they can do. And I think it's just super important that we always move these claims and issues to our insurance brokers and to the companies to deal with. And I thought Meg's advice was fantastic on when there is a lawsuit and the insurance wants to name the counsel. It is hard to not use your association's counsel. Sometimes you feel, for whatever reason, that they have your back more than anyone else will. But I promise you, the insurance company also has your back, and they have a financial interest in having your back and representing you well, and I think that was fantastic advice. So thank you, everyone, for your time today. Up on the screen is a reminder, in the last Tuesday of May, we'll continue our insurance series, and we'll be talking about the CGL policies. If you have any questions about today's program, it will be downloaded online with the slides, and Meg will send us some of the note details on the examples. And if you have any other insurance questions or any questions, please reach out to your community manager. They're working hard from home to still take care of your community. We appreciate you. Stay safe. Stay well.